I'm going to go ahead and turn the video back on, and, you know, if people are jumping in front of the camera, that's the court's fault.
Five, jury instructions.
There we go.
The judge explains the law that applies to the particular charges in the case.
So this is jury instructions at this point.
The state must prove beyond a reasonable doubt for a guilty verdict. You will receive a printed copy of those instructions. 6 is closing arguments. This is when the attorneys have the opportunity to persuade you how to decide the case. 7 is deliberations, when you will go back into the jury room and decide whether the defendant is guilty or not guilty of any particular charge. And 8, return of verdict, when you tell us your verdict. I will explain in a moment what is and what is not evidence. It is extremely important that you consider only the evidence in deciding the facts. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, socioeconomic status, or political affiliation. As part of your orientation, you were shown a video on unconscious bias. Unconscious bias is a term used by social scientists to describe the reality that everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes, that is, unconscious biases, that we may not be aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Our biases can affect how we act, favorably or unfavorably, towards someone. You should make every effort to be aware of your unconscious biases and what effect those may have on your decision making. As a judge, I am the gatekeeper regarding evidence. I determine what the law allows to be evidence. In effect, the law considers anything that is not evidence to be unreliable. That is why you may not consider non-evidence in deciding the fact. However, the law does not conclude that anything that is evidence is necessarily reliable. Determining the reliability or believability of evidence is ultimately your responsibility. You must decide what evidence is believable and how believable or persuasive any particular piece of evidence is. So, while you are not allowed to consider anything that is not evidence in deciding the facts, you are free to decide how believable or unbelievable, important or unimportant any particular piece of evidence is in deciding the facts. Evidence consists of testimony of witnesses and exhibits that are admitted into evidence. Testimony is what a witness who has sworn or affirmed to answer questions truthfully says while being examined as a witness. Exhibits are physical objects such as photographs, charts, and letters. You will be able to examine admitted exhibits during your deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it is helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defendant is innocent of any crime unless and until the state proves the defendant's guilt beyond a reasonable doubt. Questions from lawyers, or other non-witnesses for that matter, are not evidence. So, whenever I sustain an objection to a question, do not speculate about why the question was asked or what the answer would have been. This is a subtle but important point. In our everyday lives, if a friend asks us if we have seen our mutual friend's new car, we infer from the question that the mutual friend has a new car. However, it is not the same at trial. The person asking the question is not a witness and is not subject to the safeguards that the law requires before you may consider the person's word as evidence. So, in court, you are not allowed to consider questions asked by attorneys or non-witnesses in determining what the facts are, because those questions are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. For example, if a lawyer asks, was the traffic light red or green, and the witness answers green, you may take the answer as stating that the traffic light was there and that it was green. However, if the witness answers there was no traffic light, you may not take the question, the initial question, as evidence that there was a traffic light. From time to time, a lawyer may object to something that is offered into evidence. I will decide whether the objected to material will be admitted into evidence. If I overrule the objection, the material, for example, an exhibit or a witness's answer to a question, becomes evidence. If I sustain the objection, the exhibit is not admitted and is not evidence, or the witness is not allowed to answer the question. If the witness starts to answer a question before I sustain an objection to the question, you must disregard the witness's response because the response is not evidence. Occasionally, I may decide that something that had been admitted into evidence should not have been. If that happens, I will instruct you to disregard the exhibit or testimony that should not have been admitted. This means that the material is no longer evidence. You must not consider it in any way. You must treat it as if the question had not been answered or the exhibit had not been received in the first place. You must not interpret any statement, ruling, or remark I make during this trial as any indication that I have formed any opinion about the facts or outcome of this case. You, and you alone, are to decide the facts. You must decide how believable the evidence is and what weight or value you will give that evidence. You may take notes, if you wish, during the trial, and we will provide you with notepads and pens to do that. However, if you do decide to keep notes, please keep in mind that each party is entitled to the considered decision of each juror. Therefore, during deliberation, you should not give undue weight to another juror's notes if those notes conflict with your notes or your recollection of the evidence. Do not allow your note-taking to interfere with your ability to observe and evaluate testimony. Your notes may be in only two places: the courtroom and the jury room. You may not take the notes with you on lunch or overnight breaks, for example. Mr. Keenan will make sure that your notes are safe and no one has access to them in your absence. Do not discuss this case during the trial with anyone, including any of the lawyers, the parties, witnesses, your friends, or members of your family. This includes not communicating with anyone by any other means, such as telephone, text messages, email, internet chat, blogs, or social networking websites. This is a really hard and awkward part too. Do not discuss the case with other jurors or look at the other jurors' notes until you begin your deliberations at the end of the case after you have heard all the evidence and the arguments of the lawyers and been instructed on the law that applies to the case. Each of you must keep an open mind throughout the trial and must not attempt to decide the case until you begin your deliberations. And I know that's really weird and hard that we're going to put you in rooms with each other and you have one thing in common and it's this case, but you just cannot talk about it until you're deliberating because of all of these things that we've just discussed. We don't want you making up your mind ahead of time, okay? Do not make any independent personal investigation into any facts or locations connected with this case. Do not look up any information from any source. Do not communicate any private or special knowledge about any of the facts of this particular case to your fellow jurors. Decide the case only on the evidence received here in court. Do not read any news stories, listen to any radio or television reports, or read or listen to anything on the internet about this case or about anyone involved in this case. In addition to conventional research, you also must not use any internet search engine such as Google to look for any information about the case, the law that applies to the case, or the people involved in the case, including the defendant, the witnesses, the lawyers, or the judge. Do not use any map program or mapping system to attempt to view or locate any of the locations that may be discussed in the case. In short, do not communicate with anyone by any means concerning what you see or hear in the courtroom, and
keeping in mind, Multnomah County does not sequester jurors.
Other than what you
at the end of the day of jury duty, they go home and have their normal life. This is just a daytime job.
Where both the state and the defense are aware of and have the opportunity to question the sources of the evidence and to address any legal issues that may arise. That is the only fair way to decide a case. If you base your verdict on anything other than what you learn in this courtroom, that could be grounds for a mistrial, which means that all of the work that you, your fellow jurors, the parties, the lawyers, and the judge have done would have to be done all over again. That is why this is so important. If you disobey any of my orders, you could be held in contempt of court. Ignore any attempted improper communication. If any person tries to communicate with you about this case, tell that person that you cannot discuss the case because you are a juror. If that person persists, simply walk away and report the incident to Mr. Keenan or the court. You may not talk to anyone about this case, even the people closest to you, except to say you are a juror on a criminal case and Judge Moad says you cannot talk about it. After you have rendered your verdict or have been otherwise discharged by me, you will be free to do any research you choose or to share your experiences with anyone you choose, either directly or through your favorite electronic means. Remember that all phones, laptops, and other electronic devices must be turned off while you are in court and while you are in deliberation. We'll talk about this. Some judges do collect such devices from you during deliberations. We'll talk about that. But we do this in part to prevent anyone from questioning whether you are engaging in improper communications during deliberations. As I said, again, tomorrow morning we will hear the opening statements in which the lawyers will outline the evidence as they expect it to be. After the opening statements, the evidence will be presented. At the conclusion of the evidence, I will instruct you about the law that applies to this case. The lawyers will then make their closing arguments to you, and once they are finished, you will begin your deliberation. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not have a written transcript or recording to consult. That's why I urge you now to pay close attention to all of the testimony as it is given. If at any time you cannot hear a question or answer, let me know immediately by raising your hand. In performing your role, you must, of course, be fair and impartial. You must follow the law whether you agree with it completely or not, and you must not allow yourself to be influenced at all by personal feelings, sympathy for, or prejudice against anyone involved in the case. So with that, we will turn the camera down. We will turn the camera down so that as you leave the courtroom, you will not be captured on the cameras. Oh, that's even better.
Yeah, up is better than down.
Mr. Keenan informs me there are a few questions about the trial still going to the jury by Friday. Are we still optimistic that the jury will be in deliberations on Friday?
Yes, sir.
All right. So we're still planning on this getting to you by Friday, and if you do need additional time to deliberate, we will address that on Friday. Okay. So feel free to head home for the night. We'll see you. Okay. Yes. I'm going to have Mr. Keenan give you a tour of backstage and give you some passes. Now, these passes will get you into a staff-only door so that you can go immediately.
Yeah,
to the jury
judges do
deliberation
not
room.
like to talk about jury
We have
nullification.
2 deliberation rooms during the
And that's
pendency
a
of the
reason
trial.
why
So just
I would
divide
never
yourself
be a good
7
fit
and
on a
7,
jury.
and then go into those 2 separate rooms. Again, probably just pick the same room.
CGP Gray
so
does an amazing breakdown of how jury nullification works.
And 9 a.m. Well, yeah, 9 a.m. tomorrow. We'd like you in the room, ready to go, and then Mr. Keenan will come gather you up and bring you into the courtroom as soon as we are ready to.
All right, so if everyone will come with me to the door.